Thank you very much, Mr. Bailey, and it's a pleasure to serve under you. And I also want to congratulate my honourable friend from Ilford North for bringing this debate, and for him and my other colleagues who have covered so much of the core issues that are so important to that. And I will try not to repeat it because I think all those excellent points have already been made. But I would also like to thank Migrant Voice for the briefing they've provided us with for this debate today. Now, it strikes me that this issue, the Toeic issue, is yet another example of the hostile environment that has been operated by the immigration section of the Home Office in recent years, and certainly one that affects many, many of my constituents, as I, like others here, represent constituents who come from many diaspora communities, some short-term, some long-term. Now, we've had an urgent question in Parliament earlier today by the Shadow Home Secretary on Windrush. Other examples of the hostile environment include 3225, the removal of appeal rights for many examples of applications, the exorbitant cost of applications, delays in making decisions, often for years. And most worrying of all, and I see in my surgery week in, week out, is completely bizarre and arbitrary reasons for refusal for perfectly reasonable applications to come here to visit or to live, or for leave to remain or for citizenship. This is completely unacceptable environment, and it's not just about Windrush. Mr. Bailey, immigration policies and processes must be fair, they must be transparent. They should also benefit the UK and also the countries that migrants come from. Now, I want to give an example of one of my constituents, not a student actually, but still hit by the Toeic issue. He applied back in December 2012, coming as a Tier 1 entrepreneur migrant. It took a year for him to have his application refused, and it was at the hearing in December a year later, he gave oral evidence in English in the presence of a barrister from the Home Office and a judge of the First Tier Tribunal. Nobody at that hearing raised any concerns about his English language ability. The appeal was allowed at that time. Mr. A, my constituent, we waited for the implementation. However, he waited a year and 3 months. And then he was issued a refusal on the basis that he'd submitted a Toeic test certificate, which was cancelled by the Home Office. Now, it's worth noting that Mr. A, my constituent, and his entrepreneurial team partner, I'll call Mr. B, from not my constituent. Now, the Toeic certificate for Mr. B was cancelled by the Home Office, but Mr. B appealed. He was given the opportunity to retake the English language test, whereas my constituent, Mr. A, was not. Mr. B subsequently was granted his application. So why was the decision, when you've got two parallel applicants coming in the same situation to work together, why was one refused the ability to retake the English test, but one was allowed? And it's, as I say, it's important to note that Mr. A is competent in English, as he's passed the exam, the IELTS exam from Pakistan and took 5.5 band back in 2010. And I, like other members here, have met many of those who are affected, all of the people I have spoken to have been affected by this, have been perfectly able to converse with me in English, very clear English, and it seems to me that a simple remedy would be to allow them to retake the English test if there's any doubt about this, because I certainly have no doubt about the competency of English of the people I've met who've been affected. So, I mean, I have a number of questions for the Home Office that I have written to, but why they can't allow a retake of tests? Why does it take so long to get a reply from the Home Office, even after the case was won at the first tier tribunal? As Mr. A applied for his visa in 2012 according to the old category, why didn't the Home Office just grant him an in-country right of appeal according to the law at that time? Now, Mr. Bailey, as I said, my constituent is not a student, but an entrepreneur. But the impact, as other members have said, on those affected, for students, not just them personally, but the universities, for everyone affected, their families, and the reputation of the UK around the world. Now just think how a student's personal reputation in their home country, in their home community, particularly those areas which have particular respect for British ways and the British state, the ex-Commonwealth, the Commonwealth countries. How does it look to somebody who has to tell their family members, their community, that they have been told by the British government that they've failed, that they've cheated? These are good people who want to study, they want to work, they want to bring prosperity to their own communities, their own countries, and to Britain. And yet they have effectively been condemned out of hand by a government and by a country for whom they and their communities have deep, deep respect. This is shattering the UK's reputation as well as shattering lives. Now, and in this country, those who have been refused through this basis, they can't study, they can't work, they can't rent, they often have their driving licence removed from them. Their life has become, as other colleagues have said, unbearable, and they are caught between a rock and a hard place. Do they stay here, or do they go home in shame? If they stay here, they can continue to fight, and that is why we are speaking here on their behalf today. Yep. Now, there are a number of recommendations that we think the government should address. I and others have said, why not just offer a repeat, trustworthy English language test? Please clear the student names and remove what's effectively a criminal allegation against them. Put an immediate stop to detention and deportation until a decision is made and a correct process is implemented. And issue clear instructions to universities to reinstate and readmit students and allow them to complete their studies without the need to resubmit costly financial and other evidence for a new visa. And what needs to happen in the future? Universities need to have the power to decide on student admissions, including the type or accredited recognised English language test used. The government shouldn't really be involved in this process. Universities should develop their own processes, including using Skype or other technology, to interview students before leaving their countries to ascertain their level of English. And for non-student applicants, such as my constituents, there are other ways that can be done with this, but certainly Skype is an obvious opportunity. Issue the Students' Protective Rights Bill to protect their rights in the event of a university shutting down or a test centre failing or shutting down. Change students' visa sponsorship so that students get a visa to the UK to study for a particular university but can transfer that visa if they need to or wish to move universities. Not just as relevant to this debate, but so many other debates in this place, remove students from the cap on net immigration. And for those students who have already been deported or who have forced themselves to have had to leave the UK, give them the opportunity to resit the test in their own country and for their names to be removed from the allegation list so that they can get on with their lives, go back to study, take up employment, develop their business and regain their dignity. And finally, allow the students and others who were deported or left the UK the option to return to the UK to complete their studies, their work, their entrepreneurial activity following the above processes. Thank you very much, Mr. Mayor.